All right, welcome everyone to Plants to Plants Cannabis Processing Talks. Very excited today that we have Rod Kight of Kight Law with us, a longtime associate and friend of everybody here at the company, and one of the foremost attorneys specializing in cannabis and cannabis-related issues, both nationally and internationally. We are excited to have you on, Rod.
Thanks for having me, Emmett. It's really good to be with you. You know, as you said, we've known each other for years now, and we've had lots of really great, interesting, deep dive conversations over the years, on podcasts together, but, and also, just us, chatting it up, either in person or on the phone. So, I'm glad to be here and looking forward to our conversation.
Definitely. And to that point, if this talk sort of spurs your interest, there's lots more great information, both on Rod's website, as well as on our previous Plants to Plants episode where Rod is featured. So we find those links in the comments down below. So let's start off with something that's on everybody's mind right now. We've just gone through an election cycle. There's a lot of uncertainty, even leading into the election, about what impact this could have on cannabis legalization and legal status of both recreational and medical cannabis domestically and internationally. So let's start with rescheduling itself. First, could you describe for us, like, what is the current legal status of the sort of legal cannabis industry in the United States, and then what would rescheduling change for us?
Yeah, sure. So under U.S. federal law, the term cannabis is not a legal term of art, meaning it doesn't have any legal meaning. And so you'll often hear people say, oh, well, cannabis is illegal or whatever. And that's not technically true. And the reason for that is that cannabis is a botanical term. And under the law, cannabis is divided into two separate things, for lack of a better word. One is marijuana, which is illegal, and the other is hemp, which is legal. And the sole distinction between those two is the concentration of delta-9 THC. If it's more than 0.3%, then it's marijuana. If it's under or no more than 0.3%, then it's hemp. So that being said, marijuana is illegal under federal law. It's currently Schedule 1. We have 5 schedules of drugs in the United States, with one being the most restrictive, meaning that it doesn't have any medical benefits, and it has a high risk of addiction and other terrible things. Obviously, that's not true, but that's where marijuana has been since the Controlled Substances Act was enacted back during the Nixon administration. So marijuana right now is Schedule 1, and we have a recommendation that it be moved to Schedule 3, which is less restrictive. Schedule 3 doesn't mean that you can just kind of, sell it legally. Anybody can do it. It's still a drug that is regulated by the FDA. And for example, testosterone is Schedule 3. So, if you need testosterone, you can get it prescribed and whatnot, but you can't just, go out and sell testosterone at the farmer's market either, or buy it there. So, so that's what we're looking at. There's been a recommendation that marijuana be moved to Schedule 3, and as of right now, that's where we are.
Yeah, so that's a big difference between Schedule 1, which is literally no known positive or acceptable use, down to Schedule 3. How would you characterize what Schedule 3 is recognizing? This is, as I understand it, there's a lot of over-the-counter drugs, but also, like you said, testosterone being an example. Are there any products in the Schedule 3 category that are somewhat equivalent to the way cannabis is being sold today, or would this be a wholesale transformation of the way that most people would access, especially THC-containing cannabis products?
Right, sure. That's a great question. And under the answer is that no one really knows. And so, as I said with testosterone, which is just kind of it's a common type of a drug. It's a hormone, but it's a drug. It's not perceived as particularly dangerous. People are, overdosing on testosterone all the time. I'm sure it happens, but, but by the same token, it's not like you can just run, as I said earlier, the farmer's market or the grocery store and grab your bottle of testosterone and your, jug of milk to go home either. And as far as, how marijuana is sold and distributed today, it's really unlike, I think, all of the other drugs on any of the schedules, frankly. And, right now, we have two marijuana markets, right? One is the recreational or adult use market, where states say, well, regardless of federal law, we're going to legalize marijuana. And some states just create confusion, not create confusion, but it does create confusion. Call it cannabis, for example, California, a lot of the West Coasts. But we're talking about federal law here. So with that being said, some states say, oh, well, adult use, recreational, any adult can buy it. A lot of states have medical, meaning that you can buy it, but you have to have a doctor's recommendation. Because it's Schedule I, doctors cannot prescribe it because they're not authorized to do that. But you get a doctor's recommendation that satisfies the state law, boom, you can buy it. And typically you go to, what we refer to nowadays as a dispensary to do that just focuses on marijuana products. Different states have different products that are allowed and different rules and regulations regarding them. That's not how you go about buying other Schedule III drugs, right? You go to your doctor, you're given a prescription, you go to the pharmacy, and then the pharmacy doesn't hand you some botanical, it typically hands, it's a drug product as we think of a drug, some sort of a tablet or maybe even an injectable or something like that. So where marijuana is going to fit in, we don't really know. I think most people will assume that it's really just going to look the same. It's just going to have some ripple effects on the back side, so to speak. About the only thing that we can count on changing is the tax ramifications for businesses that are selling it. So not to get too wonky and geeky about tax law, but most people who are watching this probably are aware of subsection or section 280E that says if you are are selling or distributing a Schedule I or Schedule II drug, then you are not allowed to take the normal costs of business in your deduction. So if you have a business, for example, and you're selling marijuana, you've got employees, you've got your rent, you've got your marketing and so on and so forth. Normally in a business, you say, well, here's our top line income. These are our expenses. We back those out, and this is the profit that we pay taxes on. Well, none of those expenses count. So you're paying taxes on all of that right now. And so it makes it very difficult for businesses to be profitable in the marijuana sector. With a move to Schedule III, even though those businesses, the kind of traditional marijuana dispensaries, may not be or probably will not be in compliance with federal law with respect to how they go about this, they also will not have to be subject to 280E. And I think that's going to be a big boon in terms of finances. Additionally, banking, it won't make banking any more legal, but I think more and more banks will be more and more comfortable with it, as will probably investors and so on and so forth.
So you mentioned something that is really important to the whole industry as it is right now, and that's the distinction between state law and state rulemaking versus the federal law. And as it is right now, there's sort of a balance of power where the state laws have been respected and federal enforcement hasn't been, for the most part, coming in and contravening the state laws in states where there are either medical or adult use, marijuana programs. So what is the actual legal precedent right now for state regulation of these industries versus the federal regulation? Are there any, court cases that have been tried or currently being tried between the states and the federal government, or is there just essentially a tacit agreement that the federal government will not enforce against those state regulated and approved, typically licensed businesses?
Well, as a lawyer in this industry, this area of the law is highly fascinating to me, because it talks about, we have two sovereign bodies. You've got the federal government and you've got states. And traditionally in the United States, the federal government has been supreme, but where the federal government does not legislate, the states have full authority. And so we're in this position where we've got some tension. We've got the federal government says, this is illegal. You can't, participate in distributing marijuana. But you have certain states that say, oh, well, within our state boundaries, guess what? You can do that as long as you comply with our laws. And where does that balance out? And what rights do the feds have against the states and vice versa? This played out quite a bit in the early days of the medical marijuana program. There was some case law that developed, and one of the big cases was called the McIntosh case. And McIntosh involved a situation with a medical marijuana distributor and some patients. And the federal government came in and was tried to enforce the federal criminal law against these participants in the medical marijuana program in California. Meanwhile, Congress had said, even though we're the feds and even though marijuana is Schedule 1, for medical marijuana programs, states that have actual programs that they administer, we're going to tell the Department of Justice, and of which the DEA is a part of that, that they cannot use any federal funds, which is all their funds, to enforce federal law against those participants. Well, the DEA tried to enforce it anyway. And so in McIntosh, the court said, you can't do that, DOJ. You don't have any federal funds, and doing anything at all requires federal funds. So you may not interfere with the state's medical marijuana program. That rider, Appropriations Act rider that says that federal funds can't be used against medical marijuana programs, has been renewed year after year. It's still in effect today. So when we're talking about a medical marijuana program, the feds can't touch it right now. That's not true with respect to any other like adult use recreational programs. The feds can come in and raid, today, tomorrow, whatever, any kind of facility they wanted in an adult use program. That being said, the Department of Justice over the past 10 years or so has had different memos that it has issued that discuss, enforcement priorities. Like, we could go in and raid these, but that's not really a big priority for us, provided that, these businesses are licensed, they're going about it the right way, they're not a front for, the mafia or cartels or whatever, and so on and so forth, that would be a waste of our funds. We're going to allow that to happen. But it's really just sort of this uneasy tension where it's just kind of a tacit agreement not to do that. Most recently, and by most recently, I mean literally, let me see if I got it pulled up on my computer screen. Literally within the last 2 weeks, there was a court of appeal in California. So it's a state court now that was deciding kind of a boring easement case. An easement is just when someone owns a piece of land and someone else needs to use that land to get to kind of get across. Maybe, their land is back here and they, and so you apply for easements to get across. Well, there was an easement case, and the group that wanted an easement was a group that is a cannabis marijuana group to get to their property. But the owner of the land said, we don't want it. We don't want any marijuana coming across our property. And so they challenged it. And the case, which is J.C. Crandall versus the county of Santa Barbara, ruled that they weren't allowed, the marijuana group was not allowed to use this easement. But most importantly, and I'm going to read from the decision, it says, this is how it starts. The judge says, many Californians have high expectations that cannabis is legal in California. This is a reasonable assumption because Civil Code Section 1550.5 says it is. We regret to inform that cannabis is illegal in California because federal law says so. So that's pretty remarkable. A California appellate court says that cannabis is illegal in California because of federal law. Now, as a quick aside, we just talked about how cannabis is not a term of art under federal law. So this judge actually kind of got it wrong right out of the gate, said that cannabis is illegal under federal law. Hemp is cannabis, hemp is legal. Again, but what he was really talking about is marijuana. And so, we don't know yet how this particular case is going to impact California. It may be something that just no one ever notices. As an easement case, doesn't really have much in the way of impact on sort of regular ongoing businesses. Or it may be a seed that continues to sort of, grow in California and cause problems, So these are the types of things that are happening, and it's fascinating, and it's also a lot of uncertainty.
Wow. Yeah, that is such a recent case where a state judge used federal law to sort of contradict the explicit state definitions and regulatory rules that are in place. Yeah, we'll have to keep eyes out on that one. That's for sure. Hopefully
Yeah, it's
gets quickly corrected.
I hope so, because
that'd be great.
California, just as an aside, is just in free fall right now when it comes to cannabis. Here we've got, we have. I talk to clients all the time who are in the cannabis marijuana side, and they're moving to hemp because they're just losing money left and right. And then we have a decision like this that makes things even worse. And then on the hemp side of the equation, Governor Newsom just issued a really sort of regressive type of executive order that pretty much banned any hemp product at all, possession, manufacturing, distributing with
California.
any detectable amount of THC. This is California. This is the world's 7th largest economy. Traditionally a major, if not the leader in cannabis reform, is just going backwards very rapidly. So I hate to see it. My assumption is eventually this will all sort of right the wrong, and we will kind of come back around. But here's California is quickly moving to the bottom of the list of states where cannabis is legal and where cannabis reform is happening.
Well, I definitely want to come back to that comment about the hemp cannabinoids, but before we move on to the hemp side of things, help me understand who in the government at the federal level actually would be responsible for making the decision to and then setting the rules for a rescheduling at the federal level. So we've heard the DEA come out and say, give an opinion or make recommendations. The FDA has typically refused to make comment, although I think there have been a few exceptions to that relatively recently. But then do they even have the power to change this policy, or is this really going to have to go through Congress and the federal legislature? Could this be done by executive order? Like who actually makes this decision?
Great question. So under our system of governance, we have 3 branches: the judicial, the executive, and the legislative branches. And at least 2 of those branches, could conceivably do this. I mean, I guess even that would be the executive branch, which is, you talk about executive order. Could the president just say, cannabis or, marijuana is now legal? I mean, possibly, executive orders are, can be pretty broad. I don't see that that's how it's going to go down. But within the executive, you have all of the agencies. You've got the DEA, you've got FDA, a subset of the FDA is the Health and Human Services, HHS, and so on and so forth. So typically, those types of things are go through the executive agency. So in this rescheduling process right now, we have the DEA and HHS are working through that. There's a hearing that the DEA is conducting. It's been kicked down the road a little bit. There's a lawsuit about how the DEA is going to conduct the hearing. There's 43 or 47,000 comments that they have to sort through. So that's the sort of executive agency process that's happening. Of course, Congress could just make it legal. Congress could just do that. And Congress could do it in a very quick fashion. With a quick statute, and then let agencies like the FDA or direct agencies like the FDA to set up the regulations, or Congress could go into a little more detail about how it should be regulated. So there's lots of different ways that this could come about, and we don't really have one path. Congress has been, traditionally reluctant to do much of anything when it comes to marijuana reform. So we're looking to the executive branch to make this happen. Interestingly, before I sort of wrap up this response, the FDA, as you said, has just been hands off, with cannabis generally. But it just, I was looking, kind of through my daily research, and the FDA actually put on a webinar very recently. I don't have the date in front of me, but for cannabis. And I've seen this key webinar points where they talk about the background of cannabis, the pharma codynamics and pharmacokinetics. They've got approach. This is kind of for medical providers to patient conversations and how to discuss and identify. Just a way to acknowledge that physicians out there are talking to patients all the time about cannabis, and most of them don't know much about it. They don't have any guidance. So the FDA finally stepped up and gave this webinar. I think that's a positive sign. We don't know ultimately if and when marijuana is rescheduled. We assume it will be, or descheduled. What agency will be responsible for that? Probably the FDA, but the other thing that Congress could do is create a whole new agency that deals with this. So anyway, there's lots of possibilities, but that's where we are, right now.
Right, or put it under ATF, which is sort of equivalent
This is
to the
true.
way some of the states have handled it.
That's right.
Yeah. So that said, the FDA. Let's just see, is there a sense? I know that this is completely speculative and not a legal opinion in any way, but is there any sense or talk among the legal profession about, in the event of a rescheduling to Schedule 3, the impact of the existing cannabinoid drug approvals on the general salability of cannabinoids as a Schedule 3 product? And again, would state law be able to supersede that? And I'm speaking here of things like Sativex, Epidiolex, and other pharmaceutical drugs that are cannabinoids derived from the cannabis plant that have been approved by the FDA and would potentially, in theory, prevent non-pharmaceutical drugs containing those same compounds being sold to the general public.
Sure. Well, so this is the big fear that the cannabis industry has, is we sort of win the battle, lose the war. Oh, we've got it. We haven't descheduled it. We moved it to Schedule 3. This is great. Well, as we discussed earlier, moving to Schedule 3 doesn't mean that you can sell flowers and buds, or even tinctures and capsules. You've got to have an approved drug, and you mentioned several approved cannabinoid drugs that went through multi-million-dollar years-long clinical trial. There's a whole process to go, and that's what the FDA is set up to do. The FDA isn't really set up right now to oversee and regulate cannabis, at least the way it's distributed right now. And so the big fear is, oh, we get to Schedule 3, this is great, and then the pharma companies come in and just swoop it away, and dominate it, go through and have all these cannabinoid drugs and patents and whatnot. And then where is the cannabis, the currently existing cannabis industry? What's it left with? I think those fears are mostly not well supported. I think we absolutely are going to have cannabinoid-based drugs, that go through clinical trials, very specific formulations of different cannabinoids and maybe even other actives for specific, diseases and whatnot. And I think that will exist, and that will be a lane. But I think we're still going to have the traditional cannabis lane, and certainly in a minimum the flower lane. The pharmaceutical companies are not interested in selling flower. That's just not how they work. And frankly, just to push this speculation that we're having fun doing right now a little bit further, I would be doubtful if the pharmaceutical industry really is interested in cannabis at all. Cannabinoids can be made synthetically from yeast and other starters, and it's much cheaper and more, from a manufacturing standpoint, much easier for them to work with that type of cannabinoid than to grow, warehouses full of cannabis and then go through the whole process. So I think that we're going to see pharmaceutical companies enter for sure, but I think it's going to be parallel to the industry that we now see. The industry is going to change some, but I think we're going to just have these parallel paths.
Well, here's an interesting, field data tidbit I got at a recent conference. I met with a company that actually is one of the API manufacturing providers and has an approved cannabinoid drug. And the executives I was talking with said that for them, the cost to manufacture a synthetic version of THC is about $30,000. And for them to buy it at market and then bring it and refine it into a purified ingredient is less than $5,000 right now. So as of right now, the plant derived is still more cost effective than the synthetic. Now, whether in the long run that will be the case, and whether that's solely because of some of their SOPs or limitations on process they can use because of IP held by others or something like that, it's hard to really know. But that was just a little anecdotal, straight from the mouths of the people working in the pharmaceutical side of the business, indication that the plant-derived cannabinoids may have that economic edge. And they are even said that they were trying to move towards a streamlined, validated pipeline for API-grade cannabinoids from the cannabis plant, partially for that reason, rather than going the synthetic route. So
I hope that's the case
really,
in the long run. Yeah.
yeah.
But, there's the cannabis market is like, you can buy all sorts of, from flower to cannabinoids pretty cheaply now because there's a glut. And the process for the synthetics are still kind of in the works. But that's hopeful to me. I'm an advocate for the plant, and I certainly hope that that's the way it stays. So that's some good news. I appreciate you sharing that.
Right. Yes. So speaking of the plant and all the many varieties that we see it in, you've mentioned the distinction between marijuana and hemp a few times already. I understand that hemp is currently a little bit in a state of limbo itself because the Farm Bill 2018 Farm Bill has expired, and that put in these regulations for hemp, and then now we haven't seen Congress move forward a bill that has continued that program. What can you tell me about the outlook there and what the actual implications of that are for the hemp side of the business right now?
Yeah, sure. So we talked earlier about cannabis under federal law is, marijuana and hemp. Marijuana is illegal, hemp is legal. And it's legal based on the 2018 Farm Bill. So every 4 to 6 years, Congress, enacts a new farm bill, and it's huge. It's almost 1,000 pages of dense, language about everything having to do with agriculture in the United States. And in 2014, that farm bill, Congress, for the first time in almost 100 years, legalized a form of cannabis that it called industrial hemp. And that had, pretty limited definition, again, in the 800 to 1,000 pages, it was like a page and a half. 2018 came around, and the enacted a new farm bill that went a little bit deeper, expanded the definition, dropped the term industrial, so now it's just hemp, and created some regulations, or tasked the USDA specifically with creating some regulations, which it did. But the farm bill expired. It may be, I'm not sure if it's the only time the farm bill's ever expired in the history of farm bills, but certainly it's rare that it would expire. And so that puts everything that the farm bill covers in a bit of a legal limbo. What's the status? And I think most commentators, most folks that look at this say, well, there are certain types of farm subsidies and benefits and economic things that happen that now that the farm bill has expired, that can't be done. So there are farmers out there that need things. There are people that get benefits that can't get them until we have a new farm bill. But as far as the status of the law, there's nothing that undid it either. So the position that I take, and plenty of commentators, is that, hemp remains legal, just like all the other sort of things that are legal under the farm bill remain legal. But the real big issue is we are going to get a new farm bill. Is it going to be, in this lame duck session here, we're talking at the end of 2024? Is it going to be spring of 2025? Or are we going to have some log jam and it's going to be this time next year? And we're still like, where's the farm bill? No one knows that. But what is that going to mean for hemp? And we really have sort of across the spectrum of possibilities of what it could mean from hemp. So the hemp industry is based, the foundation of it is on the 2018 Farm Bill. So we've got on the one end of the spectrum, we've got what's been known as the trying to hold my hand in a way so it looks like it's a sort of a volume meter or something. So we've got what's called the Mary Miller Amendment after a congressional representative named Mary Miller from Illinois, who proposed language that I've written about, but that would really decimate the hemp industry. It really limits in the extreme what hemp is and what people can do with hemp. And that was lobbied for by a lot of the corporate marijuana interests who say, they like their lane and they don't like hemp as a competitor. There's also some concerns about it being underregulated and safety and things like that. So we've got that. We've got people lobbying for that. We've got people that are lobbying for, this is my volume meter now. We've got people lobbying for kind of keep it the same. We've all gotten used to this. We know what hemp is. It's taken a lot of sort of getting, working some kinks out, and we're on that path to really getting it worked out. We don't want to change things in the middle because it just creates more confusion and chaos. So let's just keep the same thing. And then we've got, Rand Paul just put out a bill that would up the Delta 9 THC from 0.3 to 1%. So, actually expand the scope of hemp. We don't know what's going to get enacted. Nobody, like literally nobody does. And so there's a lot of lobbying on all sides, and it'll be really interesting to see what happens, because not only the entire hemp industry, which is a $28 billion industry right now and growing, hangs in the balance, but really, and it's kind of one of my platforms, is that I think that the cannabis industry broadly, all cannabis, hangs in the balance. This is a form of legalization that certainly most people did not anticipate, but it has really, hemp has normalized cannabis. It's opened channels to states that don't have, marijuana reform. It's helped small businesses get involved. I could go on and on and on. And it's not perfect, but it's getting better and better every year. So, the whole cannabis industry, I think, hangs in the balance of what the next Farm Bill says. So it's critically important.
Yeah. So as far as what it actually says, as I understand it, well, maybe you can speak more to the actual court precedent here, but there was a point at which it was unclear about the definition around THC, and whether, for example, acid form THC and Delta 9 THC should be counted as the same end products. And then it's, as of right now, my understanding is that the precedent is basically saying that you're counting only Delta 9 THC towards the total limit of 0.3, and that 0.3 is by mass of the product that's being sold. Is that an accurate characterization of how hemp is being viewed by the courts?
Yeah, I think so. Yeah, and the courts, by and large, have not ruled on THCA, tetrahydrocannabinolic acid, and this thing you're talking about. But we're moving rapidly in that direction. But I think it's worthwhile, in the context of this question, to talk about what the courts have said. So we have the definition of hemp is broad. It's the plant Cannabis sativa. I don't have it in front of me, but I should probably know it by memory now. But and all parts of that plant, including its cannabinoids, derivatives, extracts, isomers, salts of isomers, blah 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 blah, with a Delta 9 THC concentration that doesn't exceed 0.3%. And so, there's questions back in the early days about whether CBD was legal. CBD is just such a, kind of normalized in the extreme now. But we all sort of accept that that's legal under the Farm Bill, and it's not a controlled substance. But then, Delta 8 came out, and people were like, wait a second, it's Delta 8. It gets you high if you use it. And if you look at the plain language of the law, it's clear. It doesn't say anything about Delta 8 other than that all cannabinoids with a Delta 9 concentration of no more than 0.3% are legal. But because of the way that Delta 8 tends to be produced or manufactured, namely that the plant doesn't express it in very large quantities, so you have to take CBD or some other cannabinoid and isomerize it, go through a process to transform it into Delta 8. Oh, wait, is that synthetic? The DEA has said that synthetic forms of THC are illegal. So is Delta 8 legal or not? I argued, against the currents for years that it was, and was, finally validated, thankfully, by the AK Futures decision in the Ninth Circuit in California that ruled that, that Delta 8 is legal by the plain language of the law. And then, in the history of this cannabinoid, sort of what's legal, what's not, I had reached out to the DEA inquiring about THCO. So Delta 8 is produced by the plant. It's just that's not how it's manufactured for distribution. THCO is not. The plant doesn't produce it. It is a cannabinoid, but it's completely, you use starter material from the plant, but it's not something the plant produces. And I asked the DEA, what is its opinion? And it said, oh no, this is synthetic THC. And I published a blog about that. A lot of people were very, angry with the DEA, which I understand, angry with me, kind of shoot the messenger thing. It was a big deal for a while, but it was just it. We all accepted, okay, THCO is illegal. Well, the Fourth Circuit Court of Appeals about a month and a half or two ago ruled that THCO is lawful, that the Farm Bill says a derivative of hemp is in fact hemp, and THCO is a derivative. It's not a pure synthetic because it has starter material. Well, this was sort of groundbreaking for, because the THCO market had been big, it dropped off, and but it was groundbreaking from a legal standpoint because the Fourth Circuit covers South Carolina, North Carolina, Virginia, Maryland, West Virginia. It is one of the most conservative, maybe the most conservative federal circuit courts in the country. And notably, it was quoting from the Ninth Circuit, which is historically the most liberal. It's California, Oregon, Washington, Nevada, Hawaii in the country. You never hear the Fourth Circuit, quote the Ninth Circuit, and they were quoting them regularly in this opinion. So all that is to say that, the plain language of the Farm Bill makes all of it very clear that it's only Delta 9 that's the metric. But you hear people talk about, yeah, but that wasn't congressional intent, these products that get you high. Well, it doesn't really matter what the intent was. The law is really clear. It's also conceivable that some, pro-cannabis, Congress members who knew that they couldn't get marijuana reform pushed wanted to kind of use this as an avenue for it. So finally, that's a long, front piece to talk about the THCA, and I won't talk about it very long at this moment, but just to say that there aren't court cases right now about THCA. THCA is the precursor to Delta 9. It's the form of THC that the plant most abundantly produces that degrades over time into Delta 9. The USDA rule, the Farm Bill, requires using THCA as part of the calculation before a hemp farmer can harvest the plant. In other words, the hemp farmer has to have the plant tested, and the Delta 9 plus 0.87% of THCA, that molar sum cannot exceed 0.3%. That's very clear in the law, all 50 states. However, once that's passed and the plant is harvested, the USDA test has been satisfied. The USDA's jurisdiction ends. There is no other law that says that anything applies other than Delta 9. And that's the issue that we're facing now. And there's a lot of confusion about that. The testing methods that are used by law enforcement, by regulators, are sort of antiquated as they relate to this issue. And it causes a lot of problems. So that's sort of the big issue that I'm seeing in my practice and in the cannabis industry is what is the legal status of THCA? And I strongly, state that it's legal, but that's kind of working its way through the courts right now as we speak.
All right. Well, to that point, are there any other major court cases coming down the pipeline that you're keeping an eye on? Anything people should be aware of, or is that the main one?
There are lots of battles that are going on right now. It's hard to say, which one is the most consequential. We've got, when we go back to our sort of rescheduling, we've got, a lawsuit against the DEA that it's going about it the wrong way. That could impact rescheduling. On the hemp side, you've got lots of lawsuits in various states, mostly suing states or regulatory agencies or even law enforcement agencies about the way that those states are trying to regulate hemp, alleging that it violates federal law or maybe that it violates state law. I was part of the legal team in Texas that challenged the Texas Department of State Health Services, issued a rule that said that Delta 8 was illegal in the state, and we sued. And that wasn't involving federal law at all. It was involving Texas law. And we just said that, it's possible that DSHH had the authority to do that, but they went about it the wrong way under Texas law, and we prevailed, and Delta 8 remains legal in the state to this day. And so, so you just have lots of lawsuits like that. There's a one in New Jersey. There's one pushing its way up through Arkansas. There's one in Virginia and Maryland, and there's one I'm involved with intimately about THCA in Florida. So you've got all of these battles that are raging. As far as sort of is there one sort of main case, off the top of my head, I'm not aware of any. But these are all sort of beginning to define this industry, which is normal. I think to go off on one quick little tangent, the cannabis industry, at least the sort of the legal side of things, what you talk about state legal or the hemp industry, is very new in the history of industries. And it's normal for there to be this process of defining the boundaries and what's the best practices and what should happen. And that's what we're going through. And that's what a lot of this lobbying with legislation, these rulemaking processes they're going through, the litigation and the cases, that's what all this is doing. And I think it's healthy, although it can be very maddening to try to do business in the space. So.
All right. And so, yeah, you mentioned a lot of state level cases, but it sounds like maybe the federal courts are relatively more quiet.
Yeah, federal courts are. I mean, some of those cases I talked about are filed in the federal court. I mentioned the Arkansas case. That's
Well, since we're getting into depth about the interaction of the federal laws and the state laws and the court precedent here in the United States, it's worth taking a look at what the broader international situation is. It seems like we've heard several times from various international organizations that kind of the world is waiting on the U.S. to move to make major changes to the way that marijuana in particular is regulated. However, we've seen early movers like Canada and Uruguay, of course, charging ahead with cannabis programs, and new countries starting to make either steps to do export businesses like in South Africa and Colombia and elsewhere, or starting to slowly ramp up actual adult use or broader medical programs like in, I guess, Cyprus being one place that's coming to mind, usually smaller places. But what can you say is your opinion on the trajectory of the international market if we take the US and we just say things are going to stay the same here, versus what could happen if there's actually a rescheduling and we start to open up federally recognized platform for the especially the marijuana side of the industry to stand on the international trade?
Yeah, so I mean, the international piece is incredibly exciting, and it feels like, after been doing this for a long time, that things are actually beginning to move. You're starting to see some pieces that where the momentum is such that it doesn't, it's unlikely to stall out. So, Germany is moving in a really positive direction. It looks like that's going to stay. You mentioned sort of the export, Canada and Uruguay, some of these smaller countries, but that are developing an export. South Africa developing an export market. All of those things I think are moving in the right direction. But that being said, I don't think we're quite there yet. I've got clients that, either want to export their products to other countries. And I think that they, sort of assume that, hey, is hemp legal in country X? Because as a quick aside, you cannot move marijuana across state lines, much less outside the country. But hemp you can, because it's federally legal. And so people will assume, oh, well, other countries must have hemp laws that are similar to ours. And that's typically not the case. And I think we're the only country that differentiates, is based solely on Delta 9. But in any event, countries regulate, marijuana, cannabis, differently. Every country is slightly different, and that can cause problems. Every state has different programs and different requirements and distribution models. So it can be done. For instance, Australia has an emerging medical cannabis market, and you can actually, participate in it. But there's some pretty strict requirements in order to do that. And so that's one avenue. People, hey, I want to participate in Germany. That's pretty difficult because it's a pretty closed system, by way of sort of a contrasting example. And then there's, Southeast Asia. Japan is now sort of dipping its big toe, so to speak, in CBD. That's how kind of the U.S. hemp market started. So we can see maybe that's going to, play out in a way. But to kind of pull it back, I think right now that, when we talk about international, there's sort of three different things. So each country has its model, right? And within its own sort of country, that's one piece of the international pie. But then as it relates to the United States or these other countries, typically a country tends to be an exporter or it tends to be an importer. And we don't know right now where the U.S. stands on that. On the one hand, it would be nice to be able to import very sort of low cost biomass to make certain products, and that happens, of course, in other industries with other commodities. And so I think there is, the possibility of, South Africa and some other African nations and Uruguay and it was Colombia, which is no longer. Some of those countries, it might be financially feasible to import the product for biomass, maybe even for sort of low quality sort of flowers and things like that. But on the other side, we have a pretty mature market in the way of product categories that we would like to export out. And that gets trickier because, again, what products are allowed and how, and what hoops do you have to jump through? And so, I could go on and on about it. I'll just sort of wrap up by saying it's exciting. And I encourage people who have connections and the desire to enter the international trade to think about doing so, but be prepared, for a long road. Be prepared for some dead ends, and so on and so forth, because we're in the very early days.
Speaking to some of the major executives in Canada that run some of the largest federal companies there, it's clear that a lot of the current revenue growth for those companies is coming from exports, specifically into medical programs, typically in the EU and some into Australia and elsewhere. But also that the process to get to the point where they could effectively export under, essentially pharmaceutical GMP conditions and chain of custody tracking and all of that was pretty onerous. So it is interesting to see that that's happening, because of the value of those goods is relatively high still as an export. That's being viable for a market like Canada, where production has really reached a saturation point for their domestic market, but they're able to offload inventory through this extremely rigorously tested EU GMP methodology. But the maximum volume there still is not super high. And as we know, those markets internal to the EU are still very much developing, and it's anybody's guess exactly how that's going to look. We can hope Germany opens up and becomes a really strong example market. Do you think that German market is going to come online full force and have strong sales numbers ahead of any change at the U.S. federal level? And I know that this is a little bit outside your normal domain of speculation, but do you think that could cause any sort of diplomatic challenges between the U.S. and Germany or the EU moving forward due to the Controlled Substances Act and the international treaty on controlled substances?
Well, that's exciting to think about and interesting. So two sort of responses to your questions and your comments. One, with respect to Germany, I don't anticipate diplomatic problems. The question, I think, is going to be, to what extent does Germany's embrace of really sort of full-scale cannabis reform impact the EU? The EU is such that, if a product is legal in country A, it's supposed to be legal in all the other member states. That's not how it tends to play out, but that's, the EU law says that. There was a pretty famous case about CBD that was, it was illegal in France, and there was a French case, but the EU court said, sorry, France, CBD is legal. You can't make it illegal. So we'll see how that framework works out within the EU with the German experiment. But with the United States, is the market big enough to drive legislative change in the United States, with companies that are saying, hey, look, knocking on the legislative door, look, we have a market we want to participate in. You need to help us with the laws so that we can do that. I don't know. The U.S. is sort of in an inward looking moment right now, and probably going further there. So I don't know that the EU is going to and cannabis is going to change that. But it's an interesting question, and I think people in the cannabis industry tend to be watching Germany. Is this a possible market for us? What are the pros and cons of how they're doing it? What is the reception? Are they going to trip over themselves? Are they going to succeed? These are questions. It's kind of a really cool experiment to watch. So Germany's, I think that's where that is. With respect to Canada, I just have to say, Canada has just schooled the United States in a lot of ways. And, it's a smaller country. It tends to be easier, I think, from what I gather, to kind of push through, like a lot of European countries, broad sweeping legislation and social changes in a way that's difficult for an enormous country with a lot of diversity like the United States, where it's a little bit trickier to steer this big ship. But the Canadians have done a phenomenal job, and I think that they have set themselves up to be an export, market, because people trust the Canadians and their products and their quality control, and also they're nimble and have been doing it for a while. I remember I was with a group that went to a small Caribbean nation that was soliciting, experts and proposals for a cannabis program. And it was really exciting. I drafted legislation. We had kind of players across the spectrum. We have lab experts, growing experts. I was the legal expert, so on and so forth. And we went and we made a presentation that I thought was pretty compelling. That was sort of tweaked towards their specific industry. But the reason I'm bringing this up is we got there and we were all like, oh, we're here. It felt like we're really sort of staking a claim and moving outward. Well, the Canadians had already been there. And so every question we got was, well, we talked to the Canadians and they said this. What do you think about that? So, the Canadians have done a phenomenal job in kind of getting out there in advance, because eventually the United States is going to dominate this industry, the US and the EU. It's just a kind of a matter of when. So the Canadians are kind of on a land grab right now. And I think that's going to serve them well.
Yeah, absolutely. Doing that outreach very actively. Going back to the overall international situation, though, you don't see, I don't really see anybody talking about it more recently. It seems like a few years ago this was more in the discussion, but there's no rumbling of any kind of transnational organization enforcement or changes at that transnational level, meaning like at the UN, or even with regards to funding sources like the IMF or the World Bank, where technically if you're in violation of international treaties, you might see different treatment from those large international treaty organizations. That seems to just be quiet right now. Is that the case, or do you hear anything about that?
I don't hear anything, and that's of great interest to me. So, I think it's possible that there have been some discussions. Maybe there's people who are watching this that have been like, ooh, I've been in on one of those discussions. But as far as like publicly broadcast, it really hasn't bubbled up to that, to that level, the IMF and the UN. Interestingly, when we talk about the treaty, and this is a whole nother topic, and I won't delve into it other than to say, the DEA and a lot of folks in Congress and just people who are talking, point to, well, we have a treaty obligation. We're not allowed to deschedule marijuana because of our obligations to the treaty. But my friend and colleague, Shane Pennington, has said, we've had some discussions about this, and he's talked to, people in the State Department who really are focused, like their whole area of expertise is making sure the United States is on, top of its treaty obligations, who say, it's not really like that. Actually, there's all sorts of ways that we can deschedule without violating our treaty obligations. And then even if we did, there's not really an enforcement mechanism, to make that happen. So there's a lot of issues. I think the treaty, being the block for us, descheduling is really just sort of a red herring. I don't think it's really a true legal block for us to do that.
Yeah, I don't necessarily think that the U.S. has a long history of dictating its internal policy and legislative agenda based on their or our, I should say, treaty commitments necessarily.
Yeah.
However, the smaller nations internationally that are signatories that may fear or base their policy around the U.S. and other major economic powers' position within those treaties as the de facto enforcement mechanism by way of diplomatic relations, probably has more impact. And so I haven't heard anybody say this, but the sort of elephant in the room to me on the international scene is what China, Russia, and some of those other large economic, high economic output countries that have large sway in the international treaty organization. We're seeing the rise of the BRICS, as in opposition to the G7 that's happened right now. And I wonder if they might in some way view this as a leverage point, because I haven't heard anything about China changing their policy on cannabis, although of course they've had international hemp or industrial hemp, and even my understanding is at least the manufacturer of synthetic cannabinoids regulated and allowed within China for export for maybe all along. I'm not sure if it was ever regulated out. But it does seem like a big gap for a change in the international recognition of, marijuana and Delta-9 THC specifically as a international trade commodity. So Who knows?
I love that. This is why I enjoy, one of the reasons I enjoy talking with you, Emmett, is because that's, you're exactly right. How does this play out when we talk about these big world powers? Where does cannabis fit in? I think, in one respect, maybe not very big, but on the other, it could play a huge role for the very reasons that you say. On the one hand, Russia and China in particular, their sort of cannabis culture is very different from the U.S. cannabis culture. Certainly consumption, in the way that we conceive of consumption, is just out. Russia, as I understand it, is just not cannabis friendly at all. China has a more traditional, I think cannabis sometimes is part of their, is like an herb for their food, but they don't, you don't, the way we use it is different. And so, but they might be able to use this as leverage in geopolitical diplomatic relations, or in sort of economic, as far as either closing it off or flooding the market or whatever they want to do. Yeah, I think that, that is possible and even likely in the medium term to be happening. Yeah.
Well, I guess we just got to wait and see on all these big international things. There might be some very specialized wonks out there that have the the ability to forecast, but it seems like anything could happen on the international stage at this point. But we'll be keeping our eyes on the way that the U.S. Legislative and executive changes or lack of changes move forward for the general cannabis industry, hemp and marijuana side, with post this recent election. Interestingly, this is the first election that we saw both major political parties making affirmative statements towards some degree of change in regulation towards, if not descheduling, possibly decriminalization, or some friendly sort of regulatory change towards the cannabis industry writ large. We'll see if there's any follow-up on that, and if it makes it to the legislative or executive agenda, which is a whole other question. But I think we'll both stay posted, and maybe if we see any major exciting changes coming down the pipeline, we can have a follow-up conversation and discuss it with our audience as well.
Absolutely, would love that.
Well, Rod Kight, thank you so much for joining us. Do you want to say what the best way to reach out to you is and how people should follow you?
Yeah, sure. Thanks. So, as far as email, it's rod@cannabusiness.law. Don't put .com, it's .law, rod@cannabusiness.law. And then, I write a blog. I've been writing a blog now for, I think, a decade on cannabis legal issues. And that is at kiteoncannabis.com. Kiteoncannabis.com, KIGHTONCANNIB. I just lost train of thought. But anyway, Kite on Cannabis. The main thing is my last name is spelled KIGHT, it's not KITE. Anyway, so yeah, thanks for that. Feel free to follow me, reach out, anyone who's watching this. And again, thank you for having me on your podcast. I love digging into these issues. And unlike a lot of podcasts, Emmett, you really go deep, and I appreciate that, and I appreciate the information that you and Edwin and the crew at SciPhy are going about it and putting it out there.
Well, thanks so much for joining us, and thanks to the audience as well for joining us. Of course, if you have follow-up questions, you want us to feature Rod again, please comment down below. Like and subscribe. Of course, you can find information about extraction equipment at SciPhySystems.com, SCIPHY systems.com. Find us on YouTube and all social media at SciPhy Systems. Thank you all again for joining us. Great to have you, Rod, and we'll look forward to seeing you again.